but I wanted to introduce our professor, Donna Coltharp, who will talk to you a little bit more about what the law school experience is like and show you a little bit more about what to expect once you are a law student. Professor Coltharp? She is a law alum too, by the way.
I am a St. Mary's alum. I was watching the video and reminded how, this is an old-fashioned word, but just how dear this school is to me. I had an incredibly powerful experience as a student, and although I had a long career as a criminal defense attorney after I left, I always hoped that I would be back on campus doing what I'm doing, and it's an honor, and it's an exciting place for my career to be right now. And I'm really glad to get the chance to talk to people who are thinking about St. Mary's because it means so much to me, and I always welcome the opportunity to talk to people about how meaningful a place it can be to graduate from. Can all of you hear me? I always mean to ask them. Yes, okay. All right, so I'm gonna give you a little bit of basic information and ask you a couple of questions, and then I'm gonna run you through an incredibly exciting, fun lecture on a super interesting topic. So the first thing I wanna tell you is that if this were a real class and you were my we were doing our first class period, I would ask you all to tell me something interesting about yourself, probably your favorite movie, because that's my favorite thing. But I'm not going to do that. We don't have time. I am going to tell you one interesting thing about me, and that is that there is a really big black spider crawling across my PowerPoint screen right now. So if I look a little nervous when I'm walking over there, it's just because I'm not terrified, but I do want to be sure that it doesn't drop in my lap and then I scream. So bear with me. I think I can handle it. And then the second thing I want to do is ask you all a question. If you don't have your camera on, no big deal. But those of you who do, thumbs up or thumbs up. Did you read the case that was circulated in preparation? There is no credit or non-credit. Okay, I got some, I like this one. I like this one. Okay. Okay, so that leads me to what we're going to do. So I am going to talk to you today about a case that was decided a couple of years ago that always gets a lot of interest in my Con Crim Pro class, Constitutional Criminal Law, because it's topical. And it's also just a great case to introduce folks to the Fourth Amendment. It is a story about how the law is made. And there's so many stories you can tell out of Carpenter, but that's the story I really want to emphasize today is how does the Supreme Court go about shaping and interpreting the law in such a way that the law actually changes? And Carpenter just gives us a really good, clear example of how that works. So what I'm going to do is I'm going to talk to you a little bit about the history of the law going into Carpenter so that everybody feels comfortable in the room, kind of knows what we're talking about. I may ask you a couple of questions. It's not going to hurt my feelings if you all don't want to talk. Just a little warning, there's some kind of psychology going on with all of us. We don't like to click that unmute button. Psychiatrists are studying it right now. Nobody knows why. But I really encourage you to kind of overcome that because it is the analog for class participation right now. We've got to make ourselves unclick the mute button. I do not expect you to raise your hand. Chances are I will not see it. If you have something to say or a question to ask, pop in. I do check the chat occasionally. I'm getting pretty good at that. And I'll try to answer questions as they arise in the chat room. But feel free to pop in with any questions. Okay, everybody comfortable? All right, so I assume I can share screen?
Yes, you're able to share screen.
Okay, awesome. Everybody can see the PowerPoint and me, yes? Technology is amazing. So the great thing about what we're going to talk about today is that you already know some of what we're going to talk about. It may be that you have worked in this area. It may be that you have lawyers in your family. So it may be that you know a little bit more than other people in the room. But everybody knows something about this because you've seen it on TV. You've seen it in movies. And if you had to answer a question at a cocktail party about what your constitutional rights were, chances are that somewhere in that conversation, you're going to say, well, I have a right not to be searched without probable cause, right? I have a right not to be arrested without probable cause. So you should feel a little bit comfortable with what we're talking about. I'm going to start where lawyers start in talking about the law, and that is looking at the language of the law that we're talking about. So here's what we're talking about. We're talking about the Fourth Amendment. The Fourth Amendment guarantees all of us, the people, the right to be secure in our persons, houses, papers, and effects. Persons, houses, papers, and effects. Against unreasonable searches and seizures, right? And then it guarantees that if we're going to have a warrant, it has to be issued on probable cause. An officer has to swear out facts in support of it. And that warrant has to describe particularly what it is that the officers are looking for, want to seize, or who it is that they want to arrest. Now, the first thing you need to know, the really fun thing about the law, is that every single noun in that Fourth Amendment right there has a case attached to it. That's what the law does. That's what courts do. They look at the words and they try to figure out what they mean. So the story we're getting ready to tell is a story about what these words mean: persons, houses, papers, and effects, and what these words mean: unreasonable searches and seizures. And the court has been talking about this for more than 200 years. The court has been talking about this since, well, the country has been talking about this since before we were a country. That's how they knew to sit down and write the Fourth Amendment. When the founders wrote the Fourth Amendment, they were concerned with two things. One was called a general warrant, and the other was called a writ of assistance. And they were very related. A general warrant meant that the Crown could fill out a document and say, you know, I really want you to keep an eye on that John Adams guy. Here is this piece of paper, and it gives you permission to look at everything John Adams owns, everything John Adams has ever done. Feel free to go to his workplace. Feel free to go to his house. You can rummage through his drawers. This piece of paper, Sheriff, gives you the power to do all of that. So general warrant, no limitations, no particularity. A writ of assistance was that document, except that your neighbor had it. So it wasn't the sheriff who had the writ of assistance. Oh. Right, it was your neighbor. It was like, oh, you live next door to John Adams? Feel free to go to John Adams' house on behalf of the Crown and rummage through his drawer. That was the writ of assistance. Needless to say, the founders were quite unhappy about general warrants and writs of assistance. And it appears as though they were really only being issued in the colonies, right? And this was coming to a head as we got closer to 1776, because when the king died, all of those writs were going to have to be reissued. The colonies did not want those writs reissued. And so the Fourth Amendment was literally on the minds of the founders when they revolted, right? Literally on the minds of the founders were, what are we going to do about these warrants? So I'm telling you all of that, not because it's interesting, which it really is, but because the history of the Fourth Amendment and what it meant to the founders is one of the tools that the court uses to try to tell us what it means to us. So way forward in 2018, when we're trying to figure out what to do about cell tower data, the court's looking back to the founders and saying, what were the founders worried about when they wrote the Fourth Amendment? So put a pin in that because we're going to come back to it. So what we are going to be talking about with regard to Carpenter is how technology has shaped the way that the Supreme Court has interpreted the Fourth Amendment, all the way up to 2018 when it decided Carpenter, and then ahead of us when it's going to decide even more interesting cases about technology that you are using or that is being used by police officers even as we speak. I titled this presentation, The Progress of Science, because the progress of science is a phrase used by a Supreme Court justice slightly after the turn of the century named Louis Brandeis. Has anybody ever heard of Judge Brandeis? He was kind of a firebrand, was interested in technology before there really was technology, quite worried about its impacts on the privacy of citizens. And in a case called Olmsted versus United States in 1928, Justice Brandeis expressed concern that the Fourth Amendment was not adapting to meet technology. 1928. What do you suppose the technology that the court was worried about in 1928 was?
Telephones?
That's good. It was telephones. It was surveillance of wires, wiretapping. 1928, they were wiretapping. They were wiretapping telegraph lines before we had phones. So Olmsted was a wiretapping case. And at the time that the Supreme Court got the case, the question was, does it violate the Fourth Amendment to tap somebody's phone line? Well, up to 1928, the Supreme Court had this very narrow idea of what the Fourth Amendment covered. Basically, the Supreme Court thought that it was a trespass rule. The government can't trespass on your property. It can't open your book. It can't go behind your front door. It can't go into your office. It can't pet your horse. It can't look through your buggy, right? It's a trespass rule. So when the court got Olmsted, a technology case, a surveillance case about wiretapping, it took an extremely awkward tool to decide the case, and that tool was trespass. So for Olmsted, the question came down to, hold on to your seats, where was the wire when the government tapped it? If the wire was behind your front door, then it violated the Fourth Amendment. But if they could capture your communications before the wire was on your property, then it did not violate the Fourth Amendment. Justice Brandeis thought that was the wrong result. And Justice Brandeis predicted way back in 1928 that there was going to come a day that the government, without removing papers from our secret drawers, could reproduce and expose in court the most intimate details of our lives. Way back in 1928, Justice Brandeis said that in dissenting in Olmsted versus United States. Never, ever, ever discount the power of a good dissent. That's the death of Justice Ginsburg is a good day to remember that. So Olmsted did not last long for the reasons that Justice Brandeis predicted. And in a case called Katz versus United States in 1967, the court was forced to reconsider it, basically because of that piece of technology right there, the phone booth. What happened in Katz is that Mr. Katz wanted to have a private conversation, certainly about something illegal. And so he took himself and he got into a phone booth. And back in 1967, you could close phone booth doors. When I was growing up, they were just like on the wall and there was no door. But in 67, you could close the door just like in Superman, and get on the phone. And the officers, the law enforcement were able to tap that conversation, were able to listen to that conversation. And the court had to decide whether that violated the Fourth Amendment, even though there was no trespass, because Mr. Katz did not own that phone booth, right? What was Mr. Katz trying to keep from being, from government interference in that description of the case? Was it persons, effects, papers?
Persons, actually.
Conversation, right? He was trying to keep a conversation from being heard, right? So not a person, paper, effect, but a conversation. And the Supreme Court decided that trespass was not adequate to address the concern whether that conversation should be private. Justice Harlan, a great Supreme Court justice who did a lot of work in concurrences and dissents, had been writing concurrences and dissents about this Olmsted problem for years. And he had been saying, look, it's not trespass, right? It's really about what people expect to happen to their persons, their papers, their effects, right? That's what really matters. And in Katz, the Supreme Court said, yeah, it's not about places. Forget about places. The Fourth Amendment, the Supreme Court said, is about people, not about places. And it's about what people expect. So Justice Harlan in concurrence came up with this great two-part test, which turned out to become the law. And the first one was, do you expect as a citizen that this thing be kept private? And the second part of the test was, is society going to respect that wish? Subjective test, what do we feel? Objective test, does society agree with us? Is that feeling, is that expectation reasonable? What did Mr. Katz do to tell the court that he expected his conversation to be private?
He closed the door.
He closed the door, right? He closed the door. He went into a phone booth in which you could close the door. He did not stand in the middle of the street and say, hey, do you want to commit some bank fraud? No, he went into the phone booth. He got on the phone. He probably did a little bit of this, right? So that's what he did as a subjective matter to show that he wanted privacy. The harder question is, why is society prepared to respect that? Do you respect that?
Well, there probably shouldn't be a door.
Because, oh, we shouldn't have doors if we weren't going to respect it. Is that what you're saying? Why else would we put the door on? Very good point. Why else would we put the door on? You would expect privacy if you were behind that door, wouldn't you?
Sure.
Go ahead.
Yeah, definitively. If you're closing the door, you want no one else to know it other than you and whoever you're speaking to.
Exactly. What might he have done to tell society that it wasn't reasonable? Are there things he could do that would make you think, you know, that's not so reasonable for Mr. Katz to want privacy?
If he's just sitting on the street, like, you know, among other people around him.
That's good. If he had told 3 people the day before the same information that he was communicating into the phone, right? Then you might think, well, Mr. Katz, you know, I'm not really sure you're expecting privacy in that phone conversation because you've been chatting up the whole neighborhood on the subject of
or even just having the door open.
Having the door open, yelling, I'm gonna find you and I'm gonna kill you loud enough for everybody to hear, right? You can't argue that you expect privacy. Oh, you guys are so smart. You are so smart. You are ahead of where the Supreme Court is headed. We are going to be right where you are in just a second. 2-part test. Trespass is out the door so far as we know. 2-part test. Do we expect it? Is society prepared to agree with us? Okay. All right. So that's Katz. Now, what are we going to do about those conversations, about those interests that we have told other people about? What are we going to do about the fact that sometimes we give away our person, our effects, our belongings, our spaces? We give them away to others, right?
Mhm.
We know, because we just told the Supreme Court, that whether we give something away to somebody else makes it less likely that any expectation of privacy we have is reasonable, right? Yes, and that's exactly what the Supreme Court said in a couple of cases in the 70s. The first case was Miller. The second is Smith versus Maryland. Smith versus Maryland tends to get the credit for what is now called the third-party doctrine. And what the third-party doctrine says is that if you give it away, you do not have a reasonable expectation of privacy in it. And that case involved this fancy piece of technology, fancy schmancy piece of technology that was available during the time of telegraphs, called a pen register. They're fancier now. There are still pen registers, and they're a lot prettier than this, but this is what a pen register looked like in 1979. Okay. And what a pen register did was it enabled officers without a warrant to ask a company like Southwestern Bell. None of you probably remember when we had phone companies that we all bought our phones from and that we all paid bills to, and that
Yes.
every month sent us
Yes.
a readout of all of the numbers we had called,
Yep.
right?
I remember it. Yep.
Okay, there you go, Marcus. A pen register captured those phone numbers, right? And it still does. You can still get them on cell phones. Your cell phone calls right now are subject to pen register subpoenas, okay? But this is an old-fashioned one. The victim in this case had been robbed, and then Mr. Smith started basically stalking her, parking out in front of her house, calling her. She was understandably afraid. She reported it to police. Police did some surveillance, got his license plate, used his license plate number to get his name, used his name to get his phone number out of the phone book, used a pen register and a subpoena to Southwestern Bell to get a list of phone calls that he had made. Victim's number comes up and they arrest him. And the Supreme Court says, well, Mr. Smith is the one who wanted a phone. And if Mr. Smith wanted a phone, then Mr. Smith had to know that his numbers were being provided and being kept by Southwestern Bell. How did Mr. Smith have to know? Because the Bell Telephone Company was promising security in phone numbers, right? They were saying, if you ever have any problem on your line, we will intervene, right? So according to the Supreme Court, citizens in 1979 understood that their phone data could be accessed. And because they understood that, they gave that away to the Bell Telephone Company. They didn't have a reasonable expectation of privacy in it. So one, they gave it away. Two, the Supreme Court said, it's just phone numbers. Who cares? It's just phone numbers. The Supreme Court said, what kind of privacy interest could a person have in phone numbers? And I'm going to put that question to you. What kind of privacy interest could a person have in phone numbers?
I think for me, it would depend on who they were calling and speaking to.
Yeah, who might they be calling?
Not every phone number you have that acceptance of privacy. But if you're speaking to your job or something else, then maybe you do at that in that instance.
What are some places that a person might call that a person might not want the government to know they called?
Your phone number, you may be able to pinpoint you at your workplace, where your kids go to school, your home.
Mhm.
There's a lot of things that you wouldn't want people of the external environment to be invading in.
Right.
Yeah.
Right. And it actually gets really close to very protected First Amendment rights, because you might, for example, call the political party for which you work and support, right? So it's starting to get to
Attorney.
politics. What about your church? You might be calling your church. That
Your
gets very
attorney.
close to your First Amendment rights. What about the fact that you're having an affair and you've been having an affair for 3 years and you call your paramour every week, right? I mean, I'm not condoning it, but it is private, right?
Sure.
Right.
When you
okay.
speak to your attorney, on the
When
phone.
you speak to your attorney, very good. So even just knowing that you call the Republican Party headquarters instead of the Democratic Party headquarters might be information that we don't want the government to know. But the Supreme Court wasn't really prepared to see that in 1979. Justice Thurgood Marshall wrote a dissent in Smith versus Maryland, and Justice Marshall said, it is true that you voluntarily buy a phone, but what exactly is a person supposed to do in 1979? Not buy a phone? So that's one thing. Are we really voluntarily giving up our phone numbers because we purchase the modern form of communication that is available to us in 1979? I mean, yeah, I'm not even going to tell you what I was doing in 1979. So that was one thing Justice Marshall said. The other thing Justice Marshall said was, even if we expect that Bell Telephone is going to know the numbers that we call, do we really expect that the government is going to know those numbers? So 2 points from Justice Marshall. One, not exactly fair to say we voluntarily gave this stuff up, right?
Mhm.
And two, even if it is fair to say that, it's not really fair to say that we voluntarily gave it up to the government.
Mhm.
And then three, Justice Marshall, who was always worried about civil liberties and always worried about the next shoe that was going to drop. Three, Justice Marshall said, you know, I actually don't want people knowing who I call. And I don't think most of us want people knowing who I call. But you should know that this rule about pen registers is in effect today. And people like Sprint and other cell phone providers provide pen register information based only on a subpoena, not based on probable cause. Smith versus Maryland today is good law. Smith versus Maryland applies to credit card bills. It applies to airplanes flying over your backyard at the very least 400 feet. So an airplane can fly over your backyard and take pictures of what's happening in your backyard at 400 feet. And that's a picture of what that would look like without a warrant or probable cause, on the theory, folks, that you are giving your backyard away to the public. You have given that away to third parties because planes fly over your house. Okay, planes fly over your house. So why would officers want to fly over somebody's backyard, by the way?
Because they have somebody under surveillance.
Right, and they're often, usually, this was a case in the 70s as well, they're usually looking for marijuana grows. And then in my favorite third-party doctrine case, they use this doctrine to get into your garbage, because obviously we give our garbage away when we carry it to our curb. There was an argument in California versus Greenwood that this is different because your curb is attached to your home, right? My garbage is my home. And the Supreme Court said, yeah, no, it's not your home. You are shedding it, you're giving it away. And so officers can look through garbage. Going through garbage is an extremely common and reliable method of police investigation to this day.
Really? Wow.
Absolutely. If you don't want stuff seen, you should shred it. So suppose we were, I don't know, cell phone towers. The fact of the matter is that over the course of our history, we give away more and more and more and more information every single year. Sometimes we do it by choice. We turn on that GPS function on our phones. We let our favorite clothing store send us emails or pop-up ads on our computers because frankly, that's where we shop and we like that to happen, right? We chat people up on our text phones, on our cell phones, knowing that those chat communications, or at least the phone numbers that we send chats to, could be seen by the government. And some stuff we give away just because we have to, right? We don't really have a choice. But the fact of the matter is that this is not 1928 anymore. It's not 1979 anymore. We give, as my children say, everything away. And we've been doing it for at least 20 years. In 2001, the Supreme Court started recognizing that. In a case involving technology that came out of the first Iraq War, the Supreme Court addressed the question whether officers could drive down our streets and point heat detecting devices at the walls of our house to see where the warm spots in our houses are. And the result of that technology looked like this. And you can see, what's going on at the house on the end of the street. Anybody want to guess?
I don't know. It's a tough guess. Wait a minute.
Drugs, maybe? Or like,
Yes, yes, yes. There are marijuana grows going on inside of that house. In fact, that's exactly what officers are looking for, right? They're just boom, 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 boom. Oh, look, somebody's got heat lamps going on right there, right? And not an insignificant amount of heat, right? A pretty significant amount of heat. And there were color-coded charts that allowed officers to tell just exactly how warm things were behind those doors, okay? So guess what the government argued in support of this search? They said, first of all, they said it's not a search. One, you don't have a reasonable expectation of privacy in your heat signature because the government said, we are giving our heat signatures away. They are shedding off of us. They don't belong to us. We are transmitting them into the air, into the open air, where the government is free to come along and catch them. Okay? Third-party doctrine, heat signatures. And Justice Scalia, who could write a good opinion, said that's just taking it too far. Nobody is voluntarily giving away their heat signature. One. Two, this is behind a home's door, and the home is the most sacred of Fourth Amendment protections. Absolutely the most sacred. There is very little you can do in or around a home without a warrant. And three, yeah, I mean, right now we look at this and it's a little bit of yellow blobs, and the dissent is right. You can't really tell very much about what's going on in that house from that picture. But what's next? Justice Scalia said. Wait a minute, who said that in 1928?
Brandeis.
Justice Brandeis said that in 1928, and Justice Scalia said, what's next? And what do you think he was afraid of based on just getting heat signatures from people's houses? What might you be able to discern at some point if this technology gets good enough?
Exactly where they're positioned in their house.
What they're doing. I mean, there are some intimate things that people do that shed off a little bit more heat than other intimate things, right?
Sure.
And this was subtext in this case. It actually was. I was actually teaching a writing class at St. Mary's when this case was decided, and the parties briefed, can you tell whether people are having sex using this technology? And the answer in 2001 was no. Guess what the answer is now?
Yes.
Absolutely, you can. You can tell where puppies are now. Yeah.
Well,
so
my puppy's only in one spot, so.
So the court narrowed the third-party doctrine based on the nature of the interest. This is super private stuff, right? And the voluntariness of our giving it up. We are not, in fact, voluntarily giving up our heat signatures. Interestingly enough, we are voluntarily giving up our breath. So you can do a breathalyzer without a warrant under the third-party doctrine, but not our heat signatures. All right, we are ready to talk about Carpenter. Carpenter involves cell tower data. Do I have a computer person who wants to describe how cell tower data works? I can do it, but if you know what you're talking about, you're going to be very unhappy with how I do it. Anybody here have? We need one of my sons. All right, I'm going to do it. So you've got a phone. You have activated every possible GPS aspect of that phone, right? So you use it to figure out how to go to that new place that you want to go to. You use it to keep track of family members. You use it to get your Amber alerts. You are wacko GPS plugged in, and Sprint wants to deliver. Sprint wants you to be able to have all of the location data that you, as a citizen of the modern time, believe that you're entitled to. So in order to do that, Sprint is building towers faster than you can even think about it. Sprint has new towers up all the time. I'm using Sprint as an example because that's my company. So you're driving along. How is Sprint going to tell people where you are? Your cell phone is going to ping. It's going to give off a ping. The cell phone tower is going to answer that ping. And then the tower knows where you are. And all of that information gets recorded, as far as I'm concerned, magically by elves on equipment at Sprint. And Sprint keeps that equipment for that information for a really long time. Does anybody remember how long Mr. Carpenter's information was stored for by his particular cell phone company?
I don't remember.
5 years.
5 years.
5 years. They stored data for 5 years. Okay, so for 5 years, at the request of the government, the phone company could tell the government where Mr. Carpenter was pretty much at any point in the day. This is a picture of a map that some online detectives did based on a podcast called Serial about Adnan Syed. Did anybody listen to that podcast? It's about a murder case out of Baltimore. And it involves cell phone tower data back before there were as many towers as they are now. And cell phone tower data was not as reliable then, and it became an issue in the case. And a lot of people online, basically using the transcripts from the testimony in that trial, were able to place where all of the key players were in that case based on their cell phone tower data. And you can see where the towers are located and which towers are pinging on which people. Basically, these are the kinds of maps that the government builds or has people in their IT department build to use as evidence in trials in cases like Mr. Carpenter's. All right, this is a real law school question. What happened in this case? Does somebody want to tell me what happened in this case? Like what the facts are?
Okay, if I remember correctly, he was accused of participating in a string of bank robberies. Is that
Actually, it was a tech store like Radio Shack.
Yeah.
But yes, robberies.
robbery, and they used his that was in a given amount of time.
Right. Yeah. Okay. So good. So he's suspected in a series of Radio Shack and T-Mobile robberies with a bunch of other people, over a long period of time, as is almost always the case, one or more people involved in this enterprise figured out that they were in trouble, and they sought out authorities because the person who gets there first gets the best deal.
Mhm.
And they started naming names, and that process led authorities to Mr. Carpenter. Mr. Carpenter, they wanted to be able to peg Mr. Carpenter to the robberies, so they sought his cell phone data from his cell phone company using a document called a subpoena. And a subpoena is just a request to the court to get some information. You do not have to have probable cause to get a subpoena. You have to show that what you're looking for is relevant to the case.
Mhm.
For government attorneys, subpoenas are pretty darn easy to get. Not so easy for defense attorneys, but that's another story. Pretty easy for government attorneys to get subpoenas. Don't require probable cause. A federal statute permitted them to get that information by subpoena. That information put Mr. Carpenter at relevant places at relevant times. The government secured a conviction against him. Does anybody remember what sentence the government got?
More than 100 years.
More than 100 years. The federal government does not fool around. More than 100 years. Okay. So Mr. Carpenter, who throughout, after his trial, was represented by phenomenally good attorneys, including a former clerk of Justice Scalia, a guy named Jeff Fisher, argued that this had been a search, that the search violated the Fourth Amendment because a warrant was required. Does anybody think they had probable cause to get to do this search? Suppose there was no warrant required. I know y'all don't know the definition of probable cause, but based on the information that the officers had from the informants, do you think, just gut feeling, that they had enough probable cause to get a warrant?
Well, didn't his accomplices name him as the leader?
Yes, they probably had enough probable cause to get a warrant. So Mr. Fisher, his lawyer, really needs there to be a warrant requirement, because otherwise this is probably a probable cause search and it would have been upheld. So they need there to be a warrant requirement, and we'll talk a little bit why the court requires warrants for some searches. Okay. All right. So was there a search? Was there a warrant required? What do we need to decide? What are the two questions to decide whether there's a search?
Do you? Yeah, okay. Did he expect privacy?
Did he expect privacy? Was society prepared to expect his expectation? And we know from Kyllo that when we answer that second question, we're going to look at the nature of the information that's being sought and whether the defendant voluntarily exposed that information, right?
Mm-hmm.
Did he expect privacy? As a subjective matter?
I think he did. I think he did.
And what would you say is the evidence that he expected privacy?
Because he himself wasn't given the information, it was given from a third party.
Was given from a third party, but didn't he give that information to the third party by turning on his GPS buttons? See how technical I am?
I would say he probably expected privacy in his conversation, but to say that he expected privacy in the location, I don't think so. If you're using GPS.
Because he's driving around and people can see where he's going, right?
Right.
In fact, there's a Supreme Court case called Knotts that says just that. You're driving around, people can see where you're going. You don't expect privacy. People can see that you're driving to, get donuts. So the court held that he did. What's different between that case? The court can see that you're headed for donuts instead of a salad. Or people can see that. What's the difference between that and this data? We are slicing the bologna really thin here, as Justice Sotomayor says. These are very fine differences. It has to do with the retrospective nature of this data. It has to do with the fact that they can pull 5 years of your information. So while it might be true, the court said, and by the way, the court's not 100% on board anymore that we expect the government to know where we're driving. They're kind of walking away from that in another case called Jones. But even if they were going to stay there, they're not prepared to say that we give away 5 years of our location. Why is that different? Why is I'm going to get donuts as soon as this class is done? Clearly I am, I've said it 3 times. Why is that different from, I got donuts 4.5 years ago?
Not relevant towards what the crime is in that time frame.
Right, it's not relevant. And what can you do with 5 years of information that you can't do with 30 minutes of information? Like,
you can pick and choose what you want it to say.
I can paint such a better picture of you. Is it Andrew?
Sure.
Yes, ma'am.
I can paint such a better picture of you if I know where you've been for the past 5 years, every minute of the day that you've been driving, than I can if I know that you went down to the donut shop, right?
Yes, ma'am.
I can tell people what political party you belong to. I can tell people what church you went to. I can tell people who you dated, the sexual orientation of the people that you dated, right? 5 years of data gives me a bunch of information about you that a targeted operation in which officers follow you around for a couple of days does not give me.
Right.
And so what the court said, and they might be wrong, right, is that we don't expect that kind of data to be gathered. We expect that picture of us not to be available, right? That is an expectation that we have. I mean, if you ask my kids, they would say, oh no, I totally expect the government to have that information. They would be terrible in court. But the court said, no, you don't expect that. But here's a little echo from the past. They said, you might expect Sprint to know that, but you don't expect the government to know that. Who said that in 1979?
Thurgood Marshall.
Thurgood Marshall in 1979 said, it's different depending on who has the information. It's different. You're right. We're shedding stuff off all over the place right now. We can hardly help ourselves. But that doesn't mean we want the government to, be able to pull open a file drawer at any moment and say, oh, well, here's where you were 3.5 years ago. Why is that expectation reasonable? It's reasonable because of the intimacy of the documents, right? The intimacy of what we're talking about. The scope of the information that we're talking about. And then we're going to say, the court said, that this was not voluntarily given away because we don't expect for the government to have it. All right, so in 3 minutes, somebody tell me, this is what lawyers do. What's the difference between Smith versus Maryland and the ruling and the facts there, and Carpenter versus United States and the facts there that make Carpenter, that make them both good law, right? Can they still both, here's my question. Can they still both be good law? Can Smith versus Maryland be good law? Is there a difference that makes Smith versus Maryland survive Carpenter?
I would say that it would still be considered good law considering the time, because as we grow in time, more technology advancements and stuff like that.
Uh-huh.
So people are more, I guess, equipped to be more receptive to that type of privacy.
Mhm.
That's the only type of, I guess, excuse of saying that it would be considered good law, just because they were just exposed to that.
Do you think, suppose tomorrow I found out that Apple is saving the phone numbers that I send texts to and providing them to the government by subpoena? That's an actual fact. So if the government wanted to know who I was texting, which I'm sure they do not, they could find out. Suppose I decided to take Apple to court and I said, this violates my Fourth Amendment under Carpenter. It doesn't violate my Fourth Amendment under Smith versus Maryland, does it? Does it violate my Fourth Amendment rights under Carpenter? Or is there a difference?
Is there? That's a good question.
It is a good question. I just have like 4 minutes left, so I'm going to tell you that the answer is who knows.
No, that was the first thing that came to mind when I was like,
There are some academics who believe that Smith versus Maryland cannot survive the next case, whatever that case is going to be, that they're going to have to find a different way to explain cases like the garbage case, which I think will always be good law, but they're going to have to find a different way to explain that than the third party doctrine, because basically Justice Brandeis and Justice Marshall won the issues that they wrote about, and it's hard to see how Smith versus Maryland survives. I've given you some arguments. The scope is so big. The data is retrospective, right? Those are very hard arguments to apply in the next case. How big does the scope have to be? How intimate do the interests have to be? Those are going to be hard lines for the court to draw. And it may be that they're unable to draw them. So expect to see and learn about when you're in law school. Take Concurrent Pro, because this is all coming up. Like any day, these cases are being litigated even as I speak. Expect to see a case about text messaging, right? Expect someone to take Apple to court. Expect there to be a case about whether the IP addresses that you visit, can the government find out how many times I go to Ann Taylor every day? That could be a case coming up. Those cases are in the court right now. What about our prescription drug logs? Big issue right now, given the interest in opiates, right? And there are Fourth Amendment challenges right now in the courts. In fact, there's a circuit split in the states about whether the third party doctrine applies to prescription logs. Do you give your private medical information away such that the government can go search it? Is a question that is going to be answered in the next few years. What about your neighbor's kid's drone flyover? What if it goes below your fence line in the backyard? Can the court subpoena drone flyovers, porch cams, Alexa recordings, Siri recordings, things that your computer accidentally catches on camera? Oh, a student came in my Zoom room recently and said, what about things that people say in Zoom sessions? What if they admit to a crime? What if they commit a crime? Who does that recording belong to? And what does the government have to do to get it? Very interesting question. That's one of those fun COVID. I don't know the answer, but that's what's coming up. That's where this narrative is taking us. And what I want you to know, I know I only have 1 minute. What I want you to know is that the fun thing about the law, the exciting for me, the exciting thing about the law is this conversation that we're having, these things that you've told me how smart you are, people were having in 1760, people were having in 1928, people were having in 1979. People are going to be having them 20 years from now. Same conversation, right? All of these threads about who we are and what we believe are important are there in the law, and they're always there, and they're always being talked about. The law is not static. It is a conversation. It's a conversation we're having every single day. It's a conversation people like Justices Scalia and Ginsburg, who were political enemies, but great conversation partners, are having every single day. And to me, that is the fun of the law, is that you get to be a part of and have an ear to fun and exciting and dynamic conversations. I want to leave you with a couple of pictures. This is Justice Brandeis. I love the pictures where his hair is kind of crazy. There are pictures where it's closer cut, but I don't, but sometimes I think he did not use a comb very frequently. This is Justice Brandeis. This is Justice Marshall, who was known as the great dissenter, was often in dissent. And I put them here in honor of another great dissenter, Justice Ginsburg, as a reminder that sometimes the muffled voices in those conversations are the voices that carry the day in the long run.
Mhm.